It's not like last time. What was I had the trivia name. My wife and I play virtual.
Oh,
trivia.
Annie's Food.
Yeah, and I had
Yeah.
our team name on the thing, and I was like, oh my! I couldn't get it off either. I like trying. I finally had to. I messaged Mallory. I'm like, dude, you're the host. You're gonna have to go in and change my name. I can't get it off there.
That was amazing.
Especially because it was like the official one, right? So we recorded it and sent it out to everybody. It's like, oh, there's this asshole who doesn't know how to. All right. So like you guys have seen all of the like the kind of case brief outlines and things like that. I'm gonna. So basically, what I want to do with you guys is just. I'm gonna let you guys. I'm gonna put the question up there, and then I'm gonna let you guys kind of just like say what you know, or what you think is the answer, and then we'll talk through it. If there's like confusion, like it's kind of like a group study thing, right? So you guys, in all honesty, it's gonna be funny because like you guys are gonna roll into this first class and be like, I know that, and bam, 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 and like because we're all like, huh. So hopefully you guys will go in there and just be like, yeah, the smartest people alive, and then. But here, I'm going to share the outline right there. Boop. Okay, so you guys see that? So
Yeah.
this is like super simple, broken down, but these are like the things you have to have. And then I know that like we've been talking a lot on the group meet chat about like what you need in your outline. So remember, a case brief is different from your outline, although you do pull the information that you're going to put in your outline from your case brief. But a lot of the, I'll tell you right now, like how do we get here, like the pertinent facts and the procedural history, you can leave that stuff out of your outline. And even a lot of the rules and analysis part, you can kind of leave out the real heavy stuff that you want to have in your final outline for your exam is that last part. How does the court analyze the rules? And what rule did the court establish, right? And then make sure that you also understand that this is a Supreme Court case from 1877, all right? And so this is like one of the original, like, how do we do this how do we do this like jurisdiction stuff? And so Pennoyer is where you start, and then every case you read after this starts to build on the rules in Pennoyer and clarify some of the rules in Pennoyer and really start to shape it into what we know now, right? Obviously, like I said, this is 1877. So they didn't have the internet. They didn't have like, global commerce and things like that. You guys are going to see tons and tons of like interstate commerce rules and things like that that start to take shape later on in late in the 20th century and even up till now. So just know that they're, it's 1877, they're horse and buggy. And so they're not, when they think about these things, they're thinking about it a lot different. So it'll be a lot different. So let's just get started with who, and you guys can just jump in. Who are the actual parties involved here? Like I say, it's like, who's the plaintiff?
Pennoyer v. Neff. Oh, the plaintiff?
Like say, okay, so who is Neff?
Mm-hmm.
That's the guy who owns the land, right?
Right. Well, he was the original owner of the land,
right?
And he was suing Pennoyer,
right? Who bought his land at police auction?
Exactly.
Yes.
Exactly. So are you guys all tracking that? So yeah. Neff sues Pennoyer to get his land back because suddenly this dude named Pennoyer, unbeknownst to Neff, now says he owns Neff's land. So now there's another person that's mentioned in the case book, and I think if you read the supplement, you'll figure out, like, how is Mitchell involved in this?
He was the attorney who had the default judgment against Neff. Yes. And that's how the land ended up coming into the sheriff's holding in the first place, because, I'm sure you're going to ask those questions. So
No, that's, yeah, just
yeah, I think like Neff initially, like Mitchell initially provided services to Neff
as an attorney.
Yeah.
Yes, and then I think Neff didn't pay those services, and then Neff moved to another state, So I think that's what got Mitchell all riled up, which
Yeah.
is why this whole thing started.
Okay, so cool. So now that kind of takes us to the next thing. So you guys know who the players are.
Mhm.
So then the next question is, how did we get here? And that's the facts of the case, and what's then the procedural history. Like, so we're at the Supreme Court. Obviously, there have been decisions made up until this point. So what's the and anybody can just jump in. So we can start with that, right? So Mitchell represents Neff or does some provides Neff some legal services. Then what happens?
I just have a question real quick, Paul,
Go.
before you kind of keep going into this. When you're doing this case brief outline, and I'm kind of just in my mind trying to organize how you have what other parties, and if you're using that IRAC format that they talked about, which portion would that, what are the parties be a part of in that, I guess, algorithm?
So the IRAC is actually like how you would formulate when you're writing. When you're writing, you're going to see, and D. Simone will go through this with you. So IRAC and CREAC are really how you write when you're legal writing. You say, I'm going to start, here's the issue, here's the established rule for this issue, and this is how you're going to write on your exam too. Just IRAC, here's the rule for the issue, here's how you analyze the rule to the facts in the current case, the case you're talking about, and then you come up with your conclusion, right? So IRAC doesn't necessarily fit perfect into your case brief. So your case brief has a lot more information in it than
so they're
IRAC.
separate. That's really kind of my question. Is this something like you would not use that format for?
Yeah, so what you can do is you can take your case brief and boil it down to an IRAC. And I would highly recommend that, because one thing that I learned after my first semester, unfortunately, was you almost want to start writing your exam before you even take it. And that's if you can start putting the issue and the rule, and then when you go through your exam and you start issue spotting, you've already got, bam, issue, rule, you have those first two sentences of your IRAC written, and then all you have to do is insert the facts from the current case in your analysis, and then come up with whatever conclusion, right? And generally, especially on an exam, it's never going to be super clear, so you have to come up with two conclusions, because you have to analyze it, and you're going to say, it could go this way, or it could go this way, based on the facts. And then so you'll see when you take an exam, you're not going to, it's not like when you write for legal or for your lawyering class, you're going to be like, bam, here's a conclusion, this is what's going to, this is what the judge should say. But on your exam, you're going to say the judge might go this way, if he uses this rule, or he might go this way if he uses this rule, or whatever, right?
I have a question.
Go ahead.
So going more towards the formatting, that document that Eddie sent us after the peer advisory orientation thing, is that what we're typing this information into, or are we just blank and then we write who are the parties and then write it out? Are you able to show?
Let me look. I actually was trying to look for that earlier, what he sent you guys, because I wanted to show you guys.
I'm actually looking at it right now, and it does have who was the plaintiff, who was defendant, and
the case brief template.
Yeah, it does break it down like that.
Okay, yeah. So that's where you start, right? When you read that thing that he gave you guys, when you're reading the case, so you read the case once through and get everything, kind of highlight and everything. Then you go back and you bring up that Word doc and you say, all right, now you start filling in the blanks.
While you're searching for that, Paul, when you were reading a case and you'd mentioned pulling the complete case, should we be pulling the complete cases for all these case studies okay.
No. I mean, if you're terribly confused and you have no idea what's going on, you can just, almost every case that you're going to find in your case book is like a famous case, right? And it's basically every law school everywhere teaches to these same cases. So you can Google a case and you'll find somewhere somebody did a case brief on it for you already. And so you can pull that and look and be like, all right, if you're confused, you can look and find this information. But here, this is what you guys were talking about, right? This template?
Yes. Yes.
Absolutely. This is, so step 1, read the case. Step 2, fill this out. And this is pretty much what I based my little outline I was showing you guys on, was that. Because this is like plaintiff, defendant, like what relief does the plaintiff want? You know, you can get into, because that starts to help you figure out what the issue is. And then here's the procedural history, like you start at the beginning, like trial court. And then was there an appeals decision that changed it? So on and so forth, right? And then the facts, again, you want to be real short with the facts, not something you want to get crazy into. And then here's the important part is issue, number 1 thing. All right, so back to what we were talking about. I guess we're really here, right? So we're at, we know that Neff is suing Pennoyer. We know that Neff is asking for his land back. Essentially, he's like, how did I lose my land? So the trial court, in this case, what the trial court did is actually very important. So like, who can talk about, like, so start with Neff and Mitchell, and then what happened?
So there was I think a default judgment made initially that I think Mitchell sent out a service request or some kind of request stating that you're being sued, seeking in personam jurisdiction. But obviously Neff was in California, or was out of state. And then because he didn't respond, the court said, yeah, it's fine. We'll sort of pass a default judgment. I think that's
so that is super key. Like, that is actually like the genesis of everything. It's right there. So Mitchell sues Neff for $300 because he owed him $300 for his legal services. When he sued Neff was not in Oregon. He was in California. And under Oregon rules of civil procedure, Mitchell was allowed to just announce that he was suing Neff in the newspaper. He was allowed to publish, like, hey, if your name is Neff, guess what? I'm suing you for $300. And
but then he took it like a step too far, though, and he put it in this like really minor publication that had a circulation of like 5 people that no one possibly reads.
Exactly. And so Neff is in California, and obviously he doesn't see the notice. But under the Oregon rules of civil procedure, they said, you're cool. You did your due diligence. It's Neff's fault he didn't show up. So they give him the default judgment for the $300. Then what happens?
I think Pennoyer, he bought the land at the sheriff's auction because they did the sheriff's auction in order for old boy to get his money, essentially. So once, that took place, Pennoyer is now living on his land. Neff comes back to find Pennoyer on his land. He's like, what the heck are you doing? Files for eviction on that guy.
Right? It's like straight up Wild West. Like, he shows up like, my farm. But so you kind of skipped a step. And I'll tell you, so Mitchell sues Neff, and then he gets the $300 judgment. Then he sues again because he has this default judgment, but he has no way of collecting from Neff. But he knows Neff owns this land. So he sues again, but he sues the land. And that is, so the first case, so you guys probably saw this already. So the first case was in personam, right? So he's suing the person. The second case is in rem. Now he's suing the land. He's suing the property because Oregon court, even though they may not have jurisdiction over Neff because he's not in Oregon, they do have jurisdiction over his land. And that's the in rem stuff.
So did he sue the land, or did he sort of say that because I haven't been paid yet, I want to get the land?
Yeah, well, you're right. He sued for like the court to seize the land on his behalf so that he could turn around and sell it and get his $300.
Yeah.
It's like a lien on the land, right?
Yeah, essentially. Okay. Except this was, remember, so this is like $300 judgment he has, and he successfully gets the Oregon court to give him a $15,000 deed to land that Neff owned to pay this $300. And then from there, it goes to the auction, and Pennoyer ends up with it. And like Quintel said, Pennoyer moved in, started doing his thing. So
I also noticed that he purchased the land also from the auction himself, and then he sold it to Pennoyer.
Yeah, I think that's what the case mentioned.
That's one of the tricky things he did too.
oh, okay. So
Put
Mitchell
it for
himself,
auction. Yeah, not Mitchell. Martin. He put it up for auction and then purchased it prior, so selling it to Pennoyer.
yeah, so Pennoyer is really, like, in all honesty, right? So in this case, Pennoyer is kind of innocent, kind of bystander in all this. He wasn't even really involved.
Yeah.
All he did was like, I wanted some land. I bought it. He didn't buy it illegally. He bought it the way he's supposed to. He wasn't doing anything shady. Mitchell, on the other hand, being a lawyer, he knew he was being shady. So then let's go to the next thing. So that everybody clear on like how, so that's the pertinent facts, the procedural history, how we got here, right? So, well, we didn't go all the way through the procedural history, right? So now that we get to the point that Neff sues Pennoyer, he says, you have to give me my land back, or he sues, and what's the basis of Neff's suit? Or what is Neff claiming?
He didn't get the
That he didn't
information.
get proper notice
Yeah.
was one. I think.
Personal jurisdiction.
Mm-hmm.
Yeah.
Because he didn't live in the state that they couldn't seize his land.
And also, he was basically arguing that I was reading that when Mitchell got the default, the land was not even on Neff's name at the moment because Neff was seeking the land. So he filed the default. Mitchell filed the default judgment prior to Neff even owning the land. That's one of the things that the court mentioned at the end.
See, I
Say
actually
that
was
again. Say that again.
confused by that. And
Yeah.
again, I guess this goes back to reading all the details of the case because I couldn't determine, and I'm sorry, let's start from the beginning. At the beginning of the case, the whole reason that Neff, I guess, hired Mitchell was to get this land in the first place.
Yes.
And he had gotten the ball rolling to kind of purchase this land in the state of Oregon. And all this stuff was already submitted under his name as the purchaser. So once the land was officially purchased, wouldn't it be under Neff's name? And then when the judgment then kind of came as like a lien for our 20th century vocabulary, because there was a lien, after the deed was sent, Mitchell was then able to petition the courts at that time to transfer the deed from Neff to him as, I guess, the judgment. That was my interpretation. Again,
No, and that's
I don't know shit about law. That's why I just want to
I
make
think
sure.
if you look, I think I remember if you look in some of the other sources where you can find this case, like there is a lot of like basically people think that like basically Mitchell set this whole thing up just to get this land. Like he knew that like he told Neff like, hey, go ahead, I got you. I'm gonna file the paperwork to buy this land for you. You're good to go, knowing Neff was leaving, like going to Oregon. Basically, like as soon as Neff was gone, he's like, now I'm gonna start suing him for these legal fees, and then I'm gonna end up with this property. They were thinking there was a lot of shadiness going on Mitchell's part, which led to this whole thing going on, right? And that's why he did like the minimum as far as notice goes. Like he knew that Neff's never gonna know that I'm even suing him because I'm gonna post it in this little paper that he's never gonna see, and then I'm gonna get the judgment, and then I'm gonna be able to turn around. Because that's also why, because normally, when you sue and you ask for relief, you have to also ask for like how are you, you just ask for $300. It's like $300 by, I want a piece of this land or whatever it is. Like, you kind of attach it when you're doing this thing. But Mitchell knew, like you said, Mitchell knew that like the process was still ongoing for the land transfer and the deed and everything. So he knew, he's like, I'm gonna sue him now. I'm gonna get the judgment in hand. And then as soon as the deed and all that stuff is processed and there's actual like Neff has ownership, then I'm gonna sue him again. This time I'm gonna sue him for the land to get that $300 back. All right, so But so the trial court then, so Neff comes back to Oregon, figures out like what happened. And he sues the guy that says he owns the land. And the trial court says what? Like the very first, like when Neff sued Pennoyer, what did the court say? Or how did they decide it? You won't really see a lot of what they say. They just say how they decided it.
Special verdict given.
Yeah.
Then they just evict him?
Yeah. So judgment in favor of Neff, right? So they say, yeah, you're right. They didn't have the right to take that land from you because and you have to look at this analysis, right? So, and the Supreme Court goes through it all, but they say not so much that the judgment that transferred the land, that took the land away from Neff was bad. It was the original one that actually, where they did the default judgment and gave Mitchell the $300. That was the thing that was wrong. Mm-hmm. So everything after that then automatically fails, right? And you guys will see this when you start studying constitutional law. Like once something is determined to have been invalid, has always been invalid, right? And that's why there's always these like you'll see a lot of cases where like, oh shoot, like we were never supposed to be doing that, and then things start to fall apart, right? There's I can't remember what they're called now in Maryland, where basically every death row inmate in Maryland, their case was overturned by a decision because they said you were giving the jury the wrong instructions, and so based on that, based on that one decision, every other death row inmate basically got their conviction overturned, and they had to go retry all these cases. So that's what will happen, right? In this case, it was like, now what they did is they said, giving notice via paper in Oregon to a guy who lives in California is not sufficient notice. So every case that went before them where they said, just filing a notice in the paper was good is now no good, and so it has cascading effects. You guys may have seen it in this over the summer. There was a pretty big case where they basically said like Tulsa, Oklahoma is still reservation, right? It was like, and everybody's like, oh, like so really what that was about is like, you just don't have, or the Tulsa or the state of Oklahoma and the city of Tulsa do not have jurisdiction to convict or to prosecute anybody who's Native American who lives in Tulsa or in that eastern part of Oklahoma. So now every conviction that was any Native American who was convicted by the state of Oklahoma or the city of Tulsa or anybody in the eastern part of Oklahoma, that's all overturned. Like those convictions are no good. They had no authority. And so all that stuff has to go back through. All right, so we have the trial court said, you know what, Neff, that you're right, that's your land. So then let's get to, let me get my outline up here. So now let's get to what is the issue. And we already kind of talked about it because I was just talking about it. So what's the main issue at issue here?
The issue is who has, what is the jurisdiction? Who has jurisdiction and what kind of jurisdiction do the courts have? That's the main issue.
Yeah. So can the Oregon state courts reach out to Neff in California and say, we have authority over you, essentially? There's one interesting thing, and you guys will see it like in the book, basically in the second paragraph, it says the last sentence or the second to last sentence, the defendant claims to have acquired the premises under a sheriff's deed made upon sale of the property on execution issued on a judgment recovered against the plaintiff in one of the circuit courts of the state. The case turns upon the validity of this judgment. Anytime you see that, if you see that sentence, the case turns upon this. They're telling you what the issue is. They're telling you this is the thing we're going to answer. So what they're answering is the validity of the sheriff's deed and the purchase of the land by Pennoyer. That's the issue. The issue is, does Pennoyer own this land or does Neff?
Which page are you reading from, Paul?
So on my version, it was page 22.
Oh, okay. Thank you.
He's reading from the case book, I think, not the handout that we were given.
Yeah, I'm reading out of the casebook.
Yeah.
I think, you know what, I remember now, she probably told you guys not to read the casebook, right? And just read the handout, or not?
I don't think she mentioned anything.
Yeah, it wasn't on our
Specific name.
syllabus or on her intro video either way.
It's
Oh,
on
this
page
the-
21 though, if you want to see it in our book.
Oh yeah, 21. You're right. 21. I was looking at the bottom, but the top is. Okay. I forget, when I print these things out, it prints the page number on the top. Cool. All right. So then, so we know what the issue is. The issue is this valid deed, or is this deed valid that Pennoyer has? So what are? Go back to my outline thing again. So now we're going to look at the rules and analysis. So in this case, the appellant is Pennoyer, right? So that's why it's Pennoyer v. Neff. Even though Neff initiated the action, right? So it was Neff v. Pennoyer when it started, but because Pennoyer lost and he's the one appealing, now it's Pennoyer v. Neff when it makes it up to the Supreme Court. It's Pennoyer that's asking for the relief now from a previous judgment instead of vice versa. So in this case, the appellant, Pennoyer, what arguments does his legal team make to say that he basically has a claim over this land, or legal claim? This is where things start to get
I'm
confusing.
sorry, were you asking about Neff? I missed that part I was writing.
No, I was
Were you
saying
asking about
Pennoyer.
Neff's argument, or were you asking about
Pennoyer's argument basically is that he bought the land, he duly purchased it at auction, and there's nothing illegal about his transaction.
Yeah, it's like, it's not my fault. Like,
Yeah. Also, I don't think that part was included in the handout.
Yeah, because I don't remember
Yeah.
talking much about the
I think,
Pennoyer's part of it.
yeah, because I read the whole thing. It was like probably isn't included in probably in the case book. I didn't read the case book. I read the handout.
so what you have is, and I'll tell you guys, it's
It did
on
not
page,
include Pennoyer's lawyer statement. It was just, yeah.
So
go ahead.
on the handout, it's like on the third page where it's just a second paragraph on the left where it just is literally one sentence. It says Pennoyer claims to have acquired the premises under the sheriff's deed. That's it.
Yeah. So he's saying if I bought it legally, it doesn't matter how it got to that point, it should stay with me. But this is where now, so then the court comes in and starts doing analysis, and what, and they start, this is where the court, this is like the first time, this is why Pennoyer is such a big deal for everybody. This is where the court for the first time says, well, there's in-person jurisdiction, right, or in personam jurisdiction, and then there's in rem jurisdiction, and they draw that line. They separate those two things, and they say there's certain rules that apply to people, and then there's certain rules that apply to property or things like that, right? And so this is where the court's analysis really gets into it, right? Because that gets into Neff's argument. So Neff's legal team, their argument is the original default judgment that was brought, or that was decided in Oregon, where they gave what's his name, Mitchell. I keep wanting to call him Hampton. Mitchell. When they gave Mitchell the $300 judgment when I didn't get proper notice, everything that happened after that should be invalid, because they didn't have personal jurisdiction over me at that time. Even though, so does that make sense to everybody? So really, in all honesty, it's like a weird thing, because what they're saying is if Mitchell would have tried to sue the property in the first place, like first, before he tried to sue Neff, everything would have been cool. But he didn't.
But he couldn't sue the property first because the property wasn't even in Neff's name yet.
Yeah, it wasn't.
So
he jumped the gun.
So that makes perfect sense.
But I think he could like sue the property, not to acquire the property, but just to say, hey, I haven't gotten my fees paid, give me my fees. So I think that could have worked.
Yeah, so this is where you have now, sorry, let me look up my,
It sounds like Pennoyer shouldn't really sue Neff instead of Mitchell. right? Because it's a Mitchell got him in this place.
Well, at this time, Aaron, Pennoyer owns the land because Mitchell sold it to him, remember?
Yeah, so I
Yeah,
think
but Mitchell didn't sell him a vanity property at the first place.
so. He should have. He and you know who knows? Like it may have happened afterwards. Yeah, you're right. So it's like after the court says, well, you didn't get this property legally, we're going to give it back to Neff. The Pennoyer should have then immediately gone and sued Mitchell and said, you sold me a bum piece of land, and then he probably could get relief that way.
Mhm.
You'll see some of that. You'll see some of that in this, where you have like supplemental jurisdiction, and you have like joinders and things like that, where it's like somebody sues, like I sue a company for, you know, they made a bad tire, right, and it blew out, and I crashed, and like my family died, right? So I'm suing the company. The company says, actually, it's not our fault. It's like this one other company that's over here that they make this one, they make the valves, right? You guys will get into the friggin' tire valve case. It's like so confusing. They're like, they made the valve, that's bad, so you can't sue us, you gotta sue them. And then they'll joinder, they'll pull them into the case. And then they you'll see and this is really tort stuff, but it's like supplemental liability and other things where they start to, like the judge looks at everything and says, well, it's like 50% your fault and 50% your fault, so each one of you pays. Or it's, you know what, you're fine, it's this other guy. And you'll see the same thing with like insurance companies. They'll pull insurance companies into these lawsuits too. You'll sue the company and they'll say, oh, it's not us, you're suing the, you know, the insurance company is the one that holds the liability for this. But let's talk about sorry, I just got off here. So let's talk about what Ali said about suing the land instead of suing the person and things like that. So there's really, there's two types of jurisdiction, right? So there's in personam jurisdiction and in rem jurisdiction. So, and the Supreme Court in the case, you guys can see it's like, of course, anybody who's within the boundaries of Oregon, the Oregon courts have jurisdiction over that person as long as they're there. And then they go on to say, and then in rem is if there's property within the state of Oregon, Oregon has jurisdiction over that, so they get to decide things that happen there. And then you can go, and then there's two like subtypes of in rem. There's the quasi in rem type 1, and there's a quasi in rem type 2. So, and they talk about it. They don't call it that in the case, but this is what comes out of it. So type 1 is there's a dispute about who owns the property in the jurisdiction, and that's really what Neff was bringing a quasi in rem type 1 case against Pennoyer. He says that should be my land, and Pennoyer says no, it's mine. So all right, we're going to go to court, and the court's going to figure it out. So that's a quasi in rem type 1 claim that Neff is making. Then there's quasi in rem type 2, and quasi in rem type 2 is the court has authority to render a judgment based on the fact that there is property owned within its jurisdiction, and they can only, and their judgment has to be limited to just that property itself. And that was what Mitchell sued for after he got the default judgment. That was a quasi in rem type 2, where he then said, I'm going to sue over that land because I can't go to Oregon, and you guys can't, or I can't go to California, and Oregon can't force California to enforce their judgment, right? They can't be like, hey, California, can you go to Neff's house and take his money and bring it up here? They can't do that, right? Or they could ask, but they don't have the authority. They could just be like, please, and California would be like, nah, we don't agree with what you did. So instead of doing that, Mitchell does the quasi in rem type 2 claim where he says, this guy that owns this land, I have a judgment for $300 by the state of Oregon. So you guys have now the authority to give me that land, or at least put a lien on that land. It depends on what they do. Sometimes they'll put a lien on it, and then if the guy tries to sell it, or if the guy does come back into Oregon, they can pick him up and they can collect the money. But in this case, they force the sale. They do the auction stuff. Mitchell buys it. Mitchell sells it to Pennoyer, right? So that's a quasi in rem type 2, where he just he didn't sue the land, but he sued, and his justification for the jurisdiction of the Oregon court was the land is in Oregon.
Could you
like totally confusing?
Yeah, could you explain quasi in rem type 1?
Yeah.
Because the type 2, I understood that Mitchell wants to sort of get his fees, so he sort of sues the land in order to get the fees. But
Right.
type 1, you're saying that there's a dispute over the land between Pennoyer and Neff.
Yes. So the type 1
is seeking some kind of compensation because he was sort of, or I'm not clear.
Go ahead. No, ask that question again.
No, I'm trying to sort of get clarification on what type 1 quasi in rem would be exactly.
Yeah. So quasi in rem type 1 is this case. Neff sues Pennoyer because Neff says the land is mine. Pennoyer says no, the land is mine. So when you go to court over that, that's a quasi in rem type 1 jurisdictional issue. You're saying, like Neff is saying, you don't necessarily have jurisdiction over me, but that land you do have jurisdiction over, and I want you, the court, to decide whose land it is. And that's the quasi in rem type 1 jurisdiction that Oregon has. And then the type 2 is if there's no dispute over the land, like in when Mitchell sued the land, there was no dispute that Neff owned the land at the time, and that it was in Oregon, so Oregon had jurisdiction. But what Oregon can do is say, well, we're going to reach out and we're going to take that land from you so we can pay your debt to this guy under our authority. So you can't, so don't get confused about, like, it has to be a judgment in the state of Oregon with land in the state of Oregon. He couldn't like come to Oregon with a judgment out of California and be like, hey, like the court in California said, this dude owes me $500. Can you give me that land that's in Oregon? And Oregon said, no, that doesn't work. There are ways to do that, but it's about the reciprocity clause, or what do they call it? Trying to remember. It's a clause in the Constitution where it's basically like full faith and credit. That's what it is. Full faith and credit clause, where, you know, something, if you get a driver's license in Maryland, it's good in DC and it's good in Virginia, right? That kind of thing. And sometimes the states will also honor each other's, right? So there's extradition essentially between the states. Like every state will extradite if they catch a fugitive from one state in their state, they'll extradite to that state, right? That's the full faith and credit. It's like everybody's laws are essentially on equal footing.
So for example,
Paul, would you say that the biggest distinction between type 1 and type 2 quasi and rem is that type 1, there's a dispute between two individuals over a land, and then with type 2, there's no, I guess there's no one disputing over the land.
Right. So yeah, type 1 is who owns the land. Type 2 is, will you, the court, take that land from that guy? There's no question about who owns it. It's about, I want it, or I want a piece of it, or I want some proceeds based on that land, right? So they'll either seize the land or just put a lien on it, whatever it may be. So yeah, it's a difference between question of who owns it and question of, like, can you give me some of that?
And is this only land, or could this be property,
Any
or
property.
I mean like cars or?
Yeah, so it's any so right, so there's
Like an asset, maybe?
real property. Yeah, so, and you'll see this, there'll be upcoming cases, because they'll be like, you guys will see cases where they sue somebody in, like, somebody in Florida owes somebody money in Pennsylvania, and then the person in Pennsylvania is like, that guy has a mutual fund or some bank account that's based in Delaware, and he sues Delaware. He sues in Delaware for that money for a guy that owes him money in Florida, right? Because he knows that the property, the money, or the account or whatever is located in Delaware. Don't worry about that yet. That's going to come, like, you guys are going to get that all, like, in the next couple of weeks, and that is going to get crazy. Because what you will see with some of these cases is states will fight about who has the jurisdiction. They'll be like, no, you guys don't have jurisdiction over them. They're our citizens, so you can't do that. And then there's like tension there. And sometimes what will happen is then it goes up to the federal level. Then you have like diversity and things like that. All right. So in personam, let's talk about, so one of the ways they do the analysis is they analyze in personam, and then they analyze in rem, the court does. So what are the rules? What are some of the rules that they say about in personam jurisdiction? About either A, serving notice, or B, like when does in personam count? Like if you're just driving through Oregon, do they have jurisdiction? Or if do you have to live there? Do you have to be a citizen? What is it?
I think it's about domicile.
So domicile is like is next level. So that's when if you have a person who's domiciled or a resident or a citizen of a state, they usually citizen and resident, those things are sometimes interchangeable, but the court will also make a distinction between those things. So that what that comes into is later on is if a guy's a citizen of a state, even if he's not physically present there, if he's a citizen, then you probably have personal jurisdiction over him as well. But in this case, the court for in personam just says it's all about physical location. Like, are they in Oregon right now? Or are they willing to like voluntarily present themselves under the court's jurisdiction, right? Those are like the Pennoyer rules are those two things. You either have to A, be physically present in the state at the time that the person serves you, or at the time that the incident was committed or the wrong was done. You have to be in the state, or you have to be like, all right, you know what, you're right, and you submit yourself to the court. And that's why it's always very important, and you'll hear Professor Carstens kind of hammer this home with you guys over and over and over again, is if you're going to make a claim that the court does not have personal jurisdiction over you, you have to do it right away. Because if you show up, if a guy, if you get a summons or you get a notice that says we're going to sue you, and you show up and they make their complaint and you do the answer, you gave it up. You have now voluntarily submitted yourself to the court's authority, and now they do have personal jurisdiction over you. So if you can show up to the court if you don't think they have personal jurisdiction over you, but you have to say it up front. Like that's the first thing you do is you don't have jurisdiction. Like you have to make that claim in your answer, like immediately. Otherwise you give it up. The other, so subject matter jurisdiction and some of the other types of jurisdiction, that can come up at any point. And that the court itself can be like, you know what, we don't think we have subject matter jurisdiction. They can just stop a case halfway through and be like, sorry guys, like you shouldn't have been here at all, and throw it out. But, and you'll see those cases. But for personal jurisdiction, you have to make that claim like right up front. Otherwise you're voluntarily submitting yourself. So those are, for this case, the two rules for in personam jurisdiction are A, you're in the state, in this case, you're in Oregon, or B, you show up and you say, yeah, you know what, I'll submit, here I am. Sorry, I did the thing.
I had a quick question.
I have a question.
Go ahead.
Oh yeah, my bad. So the thing is with the issue. So like, from my understanding, the issue is what got people into court in the first place. Is that what we look at as the issue, or is the issue like the other part, like where we're talking about, was he truly due process? Was it, blah, blah, blah. Because that seems like the issue that was in the appellate court versus the original issue was, hey, do you truly own that land legally? Yeah.
So the issue changes, right? And but you always have to, the issue that for your case brief purposes, and especially for when you're making your outline purposes, it's the issue that the court is making right now. Like in this case, and if it's the Supreme Court, it's always the issue the Supreme Court's deciding. And a lot of times those things, they're completely separate from what's actually at issue. Like you'll see a lot of times, so even like the courts will say, instead of like, we overturn that ruling and this person is now innocent, they'll say remanded for further proceedings. Like you guys didn't analyze this rule right. Here's the real rule. Now do it again. And they'll send it back down. And then they have to have a new trial with the new rule. So the issue does change. So you'll see, just like you said, you'll see it kind of shift. But ultimately, like I said, especially when you're reading these things, sometimes they'll say it, and they've gotten a lot better about it. Like the court's Supreme Court, especially now, when you read the newer ones, they'll say it up front. They'll be like, here you go, bang, here's 3 questions that we're going to answer right now. And then they'll do their analysis for all 3 questions. Right? They do it what the law school expects you guys to do. They do it now. But in some of these older cases, you kind of have to see like, oh, That's the key word, like I said. So this case turns upon this.
Personal jurisdiction
Right.
and
So
personal
validity
jurisdiction.
of a judgment, right? So you have to
Okay.
look for those kind of their buzzwords.
Okay.
Like, oh, there it is.
All right.
So
Okay.
Could you comment?
The issue is not ownership of the land.
right. The issue is not ownership of the land. The issue is whether or not Neff or Oregon court had personal jurisdiction over Neff when they issued that original default judgment.
Right, because I noticed that in the beginning, like obviously we're not even thinking about personal jurisdiction very in the beginning, because all you know is this guy sued this guy because he found him in his freaking land, right? So like first thing you'd be like, oh, well, that's the issue that got them into court. But the bigger issue, the issue that really matters in the beginning is the personal jurisdiction question. Okay, so that's what I was just trying to make sure I was thinking correctly.
Mm-hmm.
I want a little clarification.
Go ahead.
What are rules of Pennoyer? Physically in the state, would they have to serve you process, or can you just, does that include you passing by in the state and then you stop somewhere and then they give you the process? That should be covered under Pennoyer.
Yeah, so that analysis happens later. You guys have a whole section on notice. That's proper notice. But yeah, so like there's like personal, like you have to have actual personal service where, and then there's like it gets into weird, like, because what the court said here when they do their analysis, when you see it, and that's what this case is real confusing, because it looks like when they're doing their analysis, they're saying, yeah, this is Pennoyer's land. They did it right. But what they're saying is in the in rem case, that just publishing something in the newspaper is fine. Like, because they say, I think they say specifically at one point, they say, like, if you own a piece of land, you should know what's happening with it at all times. You should know about what's going on with taxes, who's living there. Like, and like if somebody makes an announcement in a paper or is filing some judgment against you or trying to get a deed from you, you're supposed to know about that. That's like a given. And that's what the court says here is like, Neff should have known that his land was being sold and he should have known that Pennoyer had bought it.
I'm laughing in Baltimore landlord right now.
Yeah, right. So and like those are the kind of things that like you could get away with. And they like, I don't know if you guys remember like the mortgage crisis, the big real estate drop off. What they found was they were, banks were selling mortgages to each other, just passing them around. I don't know if you guys had I had a mortgage I bought a house in 2004, and between 2004 and 2015, when I sold that house, like I was under 4 different mortgage carriers, and it was just bouncing around like crazy. And then what was happening is smart people, I was not smart at the time, but smart people were figuring out that when they were making these transfers, they weren't transferring the deed to like from one bank to another to another. They were just passing like paperwork to each other, but the deed stayed in the original bank's hand. So when the last bank that owned it tried to sue you for foreclosure, you'd be like, well, where's the deed? You have the deed. You guys say you own this land or that it's mortgaged, but where's the deed? And they'd be like, oh, they don't have it, or they don't have title. And so they lose their case. The bank loses their case against somebody they're trying to foreclose because nobody knows where the deed is and what, like crazy. So that gets into like, you have to know what's going on with your land. Like it's up to you to keep track of where these things are. If you own it, if you're the bank that owns it or you're the person that owns it, it's your responsibility to keep track of it. And nobody has to show up to you personally and be like, hey, I'm going to do this to your land. They can mail you things. They can just announce it in the paper, or they can do like this where there's a public auction. Like if you don't know that stuff's going on, that's your fault. But that's just with the in rem analysis. So the court says that was fine. What happened with the land transfer and everything else, perfectly legal. However, all of that was based on this first case where Mitchell sued Neff in Oregon when Neff was in California, and all they did was post a thing in the paper for however many weeks it was supposed to be posted. And so the court is invalidating that Oregon rule of civil procedure by saying that's not enough. That's not enough notice. You don't have jurisdiction over a dude in California. You have to either wait for him to show up in Oregon, or you have to give him proper notice, like in-person notice in California, and hope that he shows up, like volunteers to submit himself to the authority of the Oregon court. Those are like it. Like you have to, there's a lot more involved if you're suing a person. Make sense?
But didn't you just mention for the personal jurisdiction to be valid, the person has to show up immediately, right? Since he didn't show up, like Neff didn't show up, does that mean he gave up?
Yes. So if you look at, I'm sorry, because I don't have the thing that you guys have, the handout, but I'm looking at it. So if you say, so what they say is the law assumes that property is always in the possession of the owner, right? And then they go on to say service, where you announce it by the by newspaper or whatever is fine. And they say service is also sufficient in cases where the object of action is to reach and dispose of the property in the state. So they're saying that's like you can just serve that via either an announcement of some sort or something. You don't have to have like a personal service. But it says, but where the entire object of action is to determine the personal rights and obligations of an individual, that is, where the suit is merely in-person constructive service of this in this form upon a non-resident is ineffectual for any purpose. So we're saying you cannot announce this in the paper in Oregon and expect the dude in California to see it. And because the guys in California, you don't have jurisdiction over them anyway, because in personam jurisdiction is limited to Oregon. Does that kind of answer your question?
Yeah, I think so. Thank you.
So, and then, so again, if you guys have the book, I'm on page 25, like the next to last paragraph in page 25, this is where they talk about the state has the authority to adjudicate obligations of non-residents where they have no, or they don't have authority to adjudicate obligations of non-residents when they don't have any property within its limits. The last sentence in that paragraph is important. Here is the key. It says the judgment, if void when rendered, will always remain void, and it cannot occupy the doubtful position of being valid if property be found, and void if there is none. So that was where they say, just because Neff you ended up figuring out that Neff owned some property in Oregon later on, and then therefore you had this quasi in rem jurisdiction. At the time, you didn't know that, and so you were suing a person, and that person was not within your jurisdiction. That is void, and it's void forever. You can't then go back and be like, now it's void, now it's valid because we found some property. It's always void, and then anything that happens after that, because that judgment is void, anything that happens after that is also void. And then that is why they say, you know what, sorry, Pennoyer, you got a bum deal. You're probably going to want to go and sue Mitchell later on. So what else? So we talked about all of this analysis and some of these rules, right? So the big rules from, so the big rules, and I'll show you, I'm going to share with you guys my outline from this. You guys probably already, I think I already showed you guys this, but I'm just going to show you the three biggies. So here you go. So specific jurisdiction versus general jurisdiction. So this is specific. So here's these are the three rules that you should be pulling out of Pennoyer. And then after that, you're going to see with like Hess and International Shoe that these things are going to get shaped a little bit differently. But rule number one, there are three types of territorial jurisdiction. It's in personam and then in rem with two quasi types underneath it, right? So that's rule number one. Rule number two, if you're going to serve process to somebody, it has to be in the territory of the jurisdiction. And then rule three, if the defendant appears before the court, it has jurisdiction based on objective consent to the court's authority. It does not apply if it's a special appearance to challenge the court's personal jurisdiction. So this is what I was telling you about. If you show up to court, the very first thing you have to say is, I'm only here to tell you guys you don't have authority over me. Because otherwise, if you show up and you start answering the charges against you, or you start answering the complaint that the plaintiff made against you, then what you're doing is you're submitting to the court's authority. You're saying, yeah, you guys win, or not win, but you guys got me.
So did this case invent the concept of in rem?
So yes, this case is where, like in personam and in rem, where the Supreme Court said, these are two different things. Like you guys are talking about them like they're one thing, but they're two different things.
Okay, so we're not just coming into this soap opera in the middle. This is the beginning.
Yeah, you
This
go.
is the beginning of this soap opera of these concepts.
Yeah,
These weren't like floating around in the ether. This is like they decided to start using Latin words for these concepts specifically at this moment.
Right. So this is like
your choice, but okay.
Yeah, it's you start here, and that's why what you'll see is like, so right now you say like, oh, so like that personal service has to be within the jurisdiction of the state. That rule starts to get rolled over in subsequent court decisions. They're like, yeah, but you know, if you committed the crime or if you did the harm while you were in the state and then you left the state later on, like we can reach out and grab you. You guys will see that in I want to see what great case is that. Let me look at it.
And we won't find that in here because this is common law now. It's not a statute.
Right. No. What it becomes is it becomes part of like some of the federal rules of civil procedure, which don't come until way after Pennoyer. Then they start to codify these things in rules, and those are essentially like law to the court. Like if you don't follow these rules, then your whole case gets tossed. Right. But you'll see, like, especially when it comes to personal service, like the rule starts to, like, it zigzags on you. And what is implied consent? I think Hess, that was the one I was talking about. So
Hess versus Pulaski.
Which one?
Hess versus Pulaski, was that it?
Yes, that's the one where the guy's just driving through the state and gets in a car accident and then leaves the state. And then the court says, well, the harm was happened here, and because you were here and you were using the highway, you were basically consenting to jurisdiction when you were there. And so that jurisdiction continues even though you left the state. They can serve process outside of the state. That's why I said, like, so Pennoyer said the only way you can serve process is in there if you're in the state at the time that they serve the process. Then the court says, no, that's crazy, because especially if you have people just transiting through, they can murder somebody and then just leave the state and be like, sorry, you know, like that's not fair. So if you did the harm while you were in the state or you committed the crime or whatever, then their personal jurisdiction carries over even though you left the state. They can mail it to you. And so
could I ask something? In the readings, I was just going through, like, there's a lot of sentences that talk about like due process and is it like the 14th Amendment?
Mm-hmm.
Could you comment on that? I just got confused reading it.
So what happens is when you have the 14th Amendment, before the 14th Amendment, and you guys will learn this in Constitutional Law 2. Constitutional Law 2 talks about like how your personal rights, it gets into the Bill of Rights and all the amendments of the Constitution. So before the 14th Amendment, it was weird because it was like, basically they said due process and those things only applies when you're in federal court. Like we can't do anything if the states don't give you due process, or if the states don't, or if the states violate your Fourth Amendment right? If the state goes in and does an unreasonable search and seizure without a warrant, that's not a violation of the Constitution, because the Constitution only applies to federal authorities, right? That was pre-14th Amendment. 14th Amendment passes, and now they say, guess what? It doesn't matter where you're at in the United States, doesn't matter what authority is trying to violate your rights. If they violate any of the constitutional rights, which includes due process, then it's a violation of the Constitution, right? So that's the 14th Amendment's where things flipped. And then that's when, like you'll don't worry too much about that, but like the due process thing from the 14th Amendment basically says due process also applies to state courts, whereas before the 14th Amendment, due process did not apply to the state courts. Make sense?
Okay.
Yeah, I'm not saying no.
That I can put that shit off the top of my head.
Yeah, they did say the judge used that analysis, the due process clause. You know, I'm reading the brochure. They use the due process clause to basically try to justify that process was not served to Pennoyer. right? Is that this is why I believe they use it, I guess. So that part was that, huh?
No, I was going to ask you to clarify your question.
Oh, the same concept, the due process. And he says here that the justice uses the due process clause, even though the due process clause was not raised in the argument. So I'm thinking the reason why they used it is because process was not served to Pennoyer, because they didn't physically give him the process. They're using that as their I don't know, to justify their verdict, I guess. So what part of the argument would that be? So would that be part of the analysis by the judge?
So it would be, so what they said is, I think what you're saying is, so they're equating due process. So due process, although it shares like the same term as process of service, like due process is like all of the laws. Like you have to, like if you are, like if somebody violates your Fourth Amendment or Fifth Amendment or Eighth Amendment rights, any of those things, you're being denied due process. So if you're denied a trial by jury, you're being denied due process. So then, but then there is also the process of service, right? So that's the notice. And so sometimes like those things can be confusing because they're talking about like, oh, well, you know, you didn't serve process here. It's part of due process, but due process is like an umbrella that encompasses everything. Be like, are you getting treated fairly from beginning all the way to the end? All right. So in the end, court says what? What's the final holding? We know what the rules they made. They know what they, you know, the analysis they did. They, you know, how they broke apart personal jurisdiction into these different pieces of in personam and in rem and those things. What was the final word?
I think it mentioned on the 5th page, it says it's a rule of strict territoriality as the basis for personal jurisdiction did not last.
So if you're in the textbook, very bottom of page 26, it says it follows from the views expressed that the personal judgment recovered in the state of Oregon against the plaintiff herein, then a non-resident of the state, was without any validity and did not authorize a sale of the property in controversy. So they said, sorry, you didn't do it right. And so Pennoyer, you're out of luck. You never legally actually obtained that land and now it's Neff's. Which is like, again, so that's a big deal because when they say that, that's like, they're not sending it back to like, let's figure this out again. They're saying no, like nothing that ever happened after the first lawsuit was valid. So you throw all that stuff away and we're back where we were in, what was the, we're back where we were in 1866, where Neff owns some land, right? And so, and this is another cool thing about this case is like, because it's 1877, 14th Amendment was just passed like not too long before this, you know, it's basically passed right after the Civil War. So that's why you have all this talk of this thing and they're really starting to form what are these like the federal rules of civil procedure, and they're making sure that everybody's in line with these things, because if you're violating somebody's constitutional right at the state level, you're violating the federal constitution and the whole thing falls apart, right? You guys have any other questions or anything?
I know you meant, okay, so go ahead.
No, you go. I'll go after.
No, I just had a general question about like what your approach is, Paul, when you're reading a case. Like I know you mentioned all those questions about parties, how did they get here, what is the issue, rules and analysis holding. Do you sort of write that down on that piece of paper if it's there physically on like a separate piece of paper, and then you're sort of writing stuff as you're reading it? And then simultaneously you have an IRAC block as well, and you're adding things to that. I was just wondering if you could walk me through your thought process.
Yeah, totally. So I read through and highlight, and I highlight using the color codes, right? So like I showed you guys on those things, I have the issue, the history, the analysis, the rules, and the holding, right? And then when I read, I start highlighting that stuff as I'm reading it. And then there's like, so there's some of the analysis, and then here I found a rule, and here's another rule, things like that. I go through it like that when I'm reading. Then I take that information and I transfer it to that table, the who are the parties, what's these blah, 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 right? And I start to take that stuff.
That's your outline, right?
Yeah, no, that's not my own. That's my
okay.
Facebook. So I
Okay.
start pulling that information and putting it on, so I'm sorry. I'll show you guys. So what I'm talking about here is this case brief template that Eddie sent everybody. So after I've read it once and I highlight all my stuff, then I start filling in this table or something similar to this table. I don't do this in depth on every one. Some, if I know I'm on call for a case, and some professors will tell you like you're on call for this specific case, I will fill this out. I will do this hardcore. Otherwise, I'll go through and I'll just make sure I know all these things, and I might put some notes in here or something like that. Then I take that information and once I have the rule and we've gone through the class and the professor said, you know, here's what you should have done, you know, I kind of correct my case brief to be like, okay, I missed that. Then this is my outline where I then take, okay, so out of all of that stuff, out of this 10 pages of reading that you did, and then that 3 or 4 pages of case brief I did, I pulled these 3 things. Here's the big rules that I should know that are going to be pertinent when I start to do my when you take your exam and you start doing issue spotting. So right, so here I have the issues like, is there a territorial dispute? Is there a dispute with the service of process? Did somebody give consent to the court, right? Did they voluntarily consent to the court? So these are the issues. And so what I will do when I'm taking my exam, you'll get a big long freaking several pages long thing of like a fact pattern, and you just start going down, and as you see an issue, you look at your outline and you put a little check mark next to it, or you put a note next to it like, this is an issue in the fact pattern that I need to address. And then you just keep going through that all the way through as you're reading it. And then you go back, and you should, if you've done all your studying and everything right, and you made your own outline, that's the key, is like make your own. Even if you like look at other outlines to figure out like what you think you need in there, make sure you connect the dots between what you read, the notes you took in class, the case brief, and then you're connecting the dot to your final outline. This should be all you need to look at and know like, okay, bang, I remember in Pennoyer what the facts were, that Pennoyer lived in California and they sued him in Oregon. You should be able to recall that stuff. But if you can't, then you can always just go back, either look in your syllabus and figure out like where Pennoyer was, or you can just look it up in your book real quick and refresh yourself. If you did all the right highlighting like you should have in your book, then you pop it open and you can kind of see like a real short case brief on the thing and refresh yourself if you need to. Like you can compare the facts to what you're seeing you can compare the facts from the case in the book to what you're seeing in the fact pattern, and you'll be like, okay, that's either the same or it's a little bit different, right? And so the rule, Does that make sense?
So my question is kind of similar. So when we were in that orientation thing, I think Natalie mentioned like you're not going to have, or at least she didn't have time to case brief. So she was just highlighting. But if we're just highlighting, how would we know to put it on the outline? Or like, do we go back after class? Like, what can you just revisit that part?
So you can do what you can do, and what some people do is like, if you don't have the time, or if like you say like I didn't get a chance to read the case before like the day of, like I spent the 2 hours before class just going through and be like, okay, I'm ready, right? So if you do the highlighting properly, it can act as an outline for you, or not outline, I'm sorry. It can act as a case brief for you. So if you get called on a class, you can look in your book and be like, oh yeah, here you go. What you should do then is take good notes during class. Like, one of my big things is like, I just like I do for my outline, when I'm taking notes in class, I do it just like the syllabus. I'll have a set of notes that just talks about personal jurisdiction. And I go through there and I say, okay, so Pennoyer v. Neff, here's all the things I should be I should be concerned about. Whatever the professor's talking about, whatever the class is talking about, you put that stuff in there. Then you go back later on, and like I would say, at least once a month, if not once a month, at the end of every big section. So in this case, you have like specific jurisdiction versus, what was it? Specific jurisdiction versus general jurisdiction. When you finish the section on specific jurisdiction, go back, look at everything in there, and start making your outline just about specific jurisdiction, and then move on to the next thing, right? Or if you don't want to do it just by the subject matter, then just do it at least once a month, and then you guys you won't have class like the week of Thanksgiving, and then you'll have like 2 weeks after, or a week or so after Thanksgiving, to where you're just doing studying, and that's where you're polishing your outline. You're going back and you're reviewing and making sure, like, did I understand this properly? Do I need to go back and actually read the case again, whatever it is. So if you don't have, and I would say, like I said, I don't always go in and fill in those outlines unless I know for a fact, or not outlines, but I don't fill in that case brief, the table. Like, I don't go through and fill that out fully for every case unless I know I'm going to be asked a bunch of questions about it because I'm on call, or I'm confused and I need to make sure that I know what point by point by point what's going on.
I guess what I've seen so far is that the test is the class, is your grade for the most, like 75 to 100% of your grade.
Absolutely.
And so it seems like preparing for the test is what the class is, essentially. So on that point, I guess, like, these outlines that we're making, is the test based on the cases that we have reviewed in class, or is the test on anything? It could be on anything, you know, like, I guess it seems important enough to clarify.
So here's, and I don't want to confuse you guys too much with, because so your lawyer in one class is going to teach you how to write like really good legal writing, right? So you're going to go through and you're going to be like issue, rule, analysis, and you're going to be citing the case that you're pulling the rule from and all that stuff. In your exam, you're not going to be citing the cases that you're pulling the rules from. It does not matter. You can mention it. You can say the issue is the individuals challenging personal jurisdiction because they were not in the territory of Oregon at the time that that they were served process, right? The rule is from Pennoyer. You can just say from Pennoyer, the rule is if they're not in the physical state of jurisdiction, then service process is always invalid. And then you go through your analysis and you say conclusion is they didn't have personal jurisdiction, right? So you write really quickly like that because you have to go and do that for about 50 friggin' issues. You're gonna be like bang, 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 and you have to go through and do that real quick. So yes, everything that you're doing or everything you're doing is all just prepping for that exam and just being able to see the issue and pull real quick off of something, either like you know in your brain what it is, or you have it like real shorthand in your outline, like that's the issue, the rule comes from there, and then just start doing your analysis, right? Dude, if you're not typing, and you know, I don't freak you guys out, but like if you get into a final like this, and if you're not typing within, and if it's timed, so one of the things about these exams, these online exams that we're all going to be taking, is some professors will just be like, take 24 hours. I'm going to give you the exam, take 24 hours, and then, you know, from the time you open it, you get 24 hours until you have to submit your answer. Some do still, I know that Professor Carson did keep ours on a time limit, but she was going to give us, she actually gave us an extra hour. We were only supposed to have a 3-hour exam. She gave us a 4th hour because of technical issues and things like that. She's like, you guys, I'll give you guys a break. So, but if you're taking the timed exam, if it's a 3-credit class and they say you have 3 hours to take this exam, you need to have an outline that you can start typing within 10 minutes of sitting there. Like you read through that fact pattern, you start highlighting all the issues and you tick them off on your outline, and then you just need to start going. Like you're not going to have time to sit there and be like, well, let me look it up in the book and read a couple pages and see what's going on. Like you got to be like bang, 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 bang.
So is the test one big question, or is it, and then you write about it, or what's
So
what's the format?
so you'll get usually you'll get like what they call a fact pattern, right? And it's essentially all the facts to the case. It'll be like, so for this one, it would be like, Mr. Neff was represented by Mr. Mitchell, and he left the state, and then Mitchell sued him, and then blah, blah, and they'll give you all the facts from the thing. And then they'll give you a role to play in this whole thing. They'll be like, you are representing Mr. Neff, or you are representing the state of Oregon, or you are representing this, whatever it is. And they'll say, how are you going to defend your client from the initial charge? Or how are you going, if you're the state of Oregon, it'll be like, Mr. Neff is challenging Oregon's personal jurisdiction over you. How do you respond to that? And then you have to blah, 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 right? And then you'll have like 3 or 4 questions, sometimes, like, depends, 3 or 4 questions about that fact pattern. And then there's usually like 2 to 3 fact patterns in an exam. Some, not Professor Karsten's, but some professors will give you like 1 fact pattern, and then they'll give you some kind of like policy issue where you write about like, how do I feel? I remember like we took our criminal law exam, and so our policy issue was about lead in the water pipes in Baltimore City and how that has shown to affect people's cognitive abilities. And so should people who are known to have drink water out of lead pipes be, excused from certain types of crime? And so you have to just answer that as like a policy matter. You have to kind of form an opinion. And you would base it on things that you read in class, because there'll be things where they'll say, like, they'll talk about like that, like people's cognitive ability and whether or not you can charge them with first-degree murder or second, whatever, right? So there'll be some classes will have those kind of policy questions. And then some classes you'll have, like we had for evidence. I took evidence over the summer. We had 1 fact pattern, like 3 questions off the fact pattern. And then we had like 20 multiple choice questions and then like 10 short answer questions. That was awesome. I love that. So I could do this all day. but so yeah, it changes a little bit, but for the most part, it's a fact pattern that you just have to start doing they'll say, write a memo to the senior partner in your firm saying why or why not certain thing, right? So you're going to challenge somebody's jurisdiction for Civ Pro. It'll be like, you're going to challenge service process. You're going to challenge somebody's jurisdiction. You're going to challenge this rule, something like that. And then you just have to see what's going on. Cool.
So for civil procedure, like it sounds the answer to the question could be, it's like whether it's right or wrong, right? For other topic like criminal law, it's all about your debate. There is no right or wrong answer. Is that right? So
there's not a right or wrong answer with civil procedure.
Okay.
Sadly, like no, so that's the whole thing. Is like, you guys already had D. Simone, and I'm sure, did he already tell you like the answer to every question in law school is it depends?
Mm-hmm.
That is 100%. Like that's the way you have to approach every exam. Like I said, you're not going to make hard conclusions on your exam. You're going to say, well, if the court analyzes that, he owned some land, or like, because it was silliness. Like I'll tell you, like we had one where it was like one question in Civ Pro where it was like a company in Florida built this thing, and they built it specifically for catching bears in Montana. And they sold it to a company in Idaho who then went to Montana and installed the thing, right? And then the bear trap was like, killed a person, or she cut her leg off. And then so she sues the company in Florida in Montana. And they're like, are they allowed to do that? And then you have to sit there and be like, well, like there's the guys in Idaho who might have some responsibility because they didn't follow the instructions. And then, so you go through this whole thing. That's the kind of stuff that there's no really right answer. So you just have to say, here's some rules, and here's how I would apply them. And so maybe if they apply this rule, it'll go this way. If they apply this rule, it will go this way. So you make sure you say both ways. It's not like in lawyer one, you're going to take a position because you're either a defense attorney or a prosecutor, and you're going to say, he's guilty because of this, or he's innocent because of this, right? Instead, you're going to say, maybe not.
There's no points for persuasive conviction.
No, it's all about how persuasive you are. It's like you make the argument, and then you you say, well, it also go the other way. Right? So you have to make the argument. You have to make a persuasive argument both ways. Is what you have to do.
This is kind of off topic, but do you have any insight onto our professor? Like anything we should know?
Carson, she's awesome. Like,
Oh, she's okay.
she's cool. She's cool. Super professional. Stays on point. She has like the best PowerPoints. Most law professors suck at PowerPoint, and they'll just like copy a statute and paste it onto a PowerPoint slide and be like, read this, and like you're supposed to understand. But she's like, she does really good. She'll give you guys flowcharts. She's super smart. She actually I think she's writing a civil procedure textbook right now. She was in the middle of, she was hitting some deadlines while we were in class with her. She in her practice, in her professional practice, she was actually like I think she was just I don't think she was a partner, but she was an associate of shoot, I can't remember the dude's name now. The guy who was the special prosecutor for the Russia investigation, and used to be the head of the FBI. What was his name?
Mueller?
Yeah, Mueller. She was in Robert Mueller's law firm, and she was like basically like she worked directly for that dude on the private side, not on the government side. So like she's a big to do. She's like, you know, really smart and really good. And then I know I think it was Justin shared with you guys D. Simone's background. Like that dude argues in front of the Maryland Court of Special Appeals like all the time. That's a big deal. And then who else do you? Oh, I don't know who the other. You guys are taking contracts or crim law?
Crim.
Criminal law.
And I don't know the Selnick.
Yeah.
Yes.
I don't know or her.
Is Carson's a cold caller?
Yes. So she's not going to. Well, she's highly unlikely just to point at you and say go. What she's going to do is she's going to open it up, and she'll have a list. She'll let you know. She'll have a list of people like, hey, you haven't participated yet, and if we're in class and nobody's participating, I'm going to call on you. So she expects everybody just to come prepared, and like, you know, it's a thing of mine. Like if I know a professor's not a cold caller, and I, you know, because whatever 15% of your grade is a participation. Yeah, I'll shoot up my hand like right away and just like answer the easiest question. Just be like, I said something. Remember, mark that down. Like I said, Neff sued Pennoyer. Remember, I was so smart. Like that. So you may just want to, you know, just get your things in, and if you do that, she's a lot less likely to call on you when everybody's silent and everybody's confused. She may change the way she does it online, because that was
for sure.
we had her for most of the semester in class, or at least half the semester in class, and then I think she was still trying to get used to online stuff. And I think most of the professors are going to be a lot better about the online stuff, at least as far as like calling on people, because we went halfway through the semester and it became like these lectures. Like it was basically like 2 to 3 hour lectures. And it was maddening. Because I don't think they understood yet how to interact with people online. And they should be a lot better about it this semester, where they're going to be like, all right, so this is just the way it is. They have to make it work and not just sit there and talk to you guys for a couple hours. Anything else?
Thank you. Seriously.
No, you guys are awesome.
Thank you.
Thank you very much. That's very helpful.
Hey, and I don't mind. You guys can throw me under the bus. If I said something and you guys repeat it, and then she's like, she'll be like Edward, and she'll be like, okay, that guy's stupid. I understand.
Yeah.
But good luck, and like if you guys want to do this like once a month or something, like I know Eddie was talking about, and we definitely will come back around with you guys like on a kind of a formal basis, where we say, okay, based on your first month here, let's talk about outlining and what you should have been pulling out of all this stuff you've been learning. We'll go through that with you guys, but and then we'll set something up. I know you guys had a video with Dean McLean on issue spotting probably in your orientation. Does that sound familiar?
Haven't done it yet.
Go back and watch it now.
Can you repeat the name? I didn't hear it.
Dean McLean?
Yes.
Okay. So we can also arrange with him. We did it for the last class as peer advisors, and we'll do it for you guys too, where we'll actually do one of these with him. He has a super awesome issue spotting class that will like, it'll freaking turn a light bulb on in your head. You go like, oh my God, this is what law school is all about. I understand now. Because it's,
Yeah, that would be amazing.
yeah, you guys will need that for exam taking time, because no matter what, I can sit here and try to explain to you an exam, and then you go sit down and you look at that thing and you're like, bummer. But you guys got it, man. It'll be fun. I'm jealous. You guys only have 3 classes. I have 4 classes. And all of them are paper writing classes. Sucks. I don't have any.
We have legal writing or legal research, but it's only half the semester.
Oh, that's right. ILR is pretty easy. It's so cheesy because, I mean, so, and I'll give you this tip about it. Like, when he explains to you what your final project is, you're gonna be like, really? Like, and it really is that simple. Like, your paper for legal research is gonna be like, I started with Google. I entered this term into Google and it popped up with these results. I clicked on this thing. That's what you have to write on a paper, like step by step by step by step. And they're gonna, and so like the whole class is gonna be him kind of introducing that kind of framework. And then all you do is just repeat it to them. But that's cool. And then advanced legal research is essentially the same class, but instead of they hand feed you topics in your initial legal research and advanced legal research, you pick your own topics and do them that way. So it's essentially the same class. It's pretty easy.
Where was that issue spotting video? That
there should be something in your orientation thing. There should be some issue spotting or some class from, I know Dean McLean gave something. If he didn't give you one specifically, let me know, because then I will make sure that we'll hook you guys up either way. We'll get with him and make sure that you guys get that.
I don't see it in the modules, if that's what we're talking about.
Okay.
There's like 6 modules.
I couldn't see
The
any.
one that Dean McLean did one that was like how to be a law student, like how to be a successful law student or something. And he does talk somewhat in there about like briefing and issue spotting and outlining and stuff.
Okay. Yeah, then we'll definitely get you guys a class from him. Like, usually it takes like 30 minutes. We used to do it like, so we had classes that started at 6:30, and so we'd have everybody show up at like 6 or even 5:30 before class, and then he would come in and do it in person. We'll have him do the same thing with you guys, except online, obviously.
For the legal research, the professor asked us to self-study the CALI. Did you guys do that, or is that a requirement? He mentioned he won't evaluate on that though.
The Cali stuff,
Yes, and that's very time consuming.
Mm-hmm. It is.
So we have to go over all of them.
It will be helpful. It will be super helpful if you do. So the problem is for you guys, unfortunately, is like usually you take your intro to legal research in the library. You take the class in the library. And so you do a lot of the physical, like, let's go pull a book out and let's open it up and let's look at these things. But you guys can't do that. So that's why he's having you take the Cali lessons instead, because that's the only way to kind of replicate that stuff, even though it's still not 100%. But yeah, you should. You got to understand how to pull like the physical books and not just like put in search terms into Westlaw, which always used Westlaw, never used Lexis.
Is this Grayek?
Thank you.
Yeah,
yes.
Great. But yeah, I'd be interested to see. I mean, it's interesting to me how they have constructed that class now that you can't physically be in the library. It's kind of, I would say that would be number one bummer about that. But it is going to seem like a lot of work for a 1-credit class, because you have to do research, and so you're like doing a lot of stuff. But again, because they feed you the topic, they know that there's an answer out there for the questions they ask you. So just keep doing the search and follow the Westlaw stuff. You'll be all right. I would take some of the Westlaw gives you some little lessons in Westlaw itself. It'd be like, same thing as like the Cali lessons, but like Westlaw or LexisNexis specific. If you have time, take some of those too. just there's nothing wrong with getting to know Westlaw and that stuff really good because you can use the shit.
Also, for the final exam for civil procedure, like it said we will use some exam software, and I'm not sure how the interface will be like. But are we going to have access to like our own Word or Excel file where we can copy and paste, or copy and paste is not allowable?
So it depends. There's two different ways. So Exam4 is the software that they use for managing because everything has to stay anonymous. They can't grade you on a curve if they know who you are. It's like against the rules. So what you'll do is it depends on how they administer there's two ways to administer the exam on Exam4. It's either you go in and you just download the final, and then from their website, instead of downloading their software, you just download the final from their website, and then you do it on your own Word document. You just blah, 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 type in all your answers, and then you save it, and then you just submit it through the Exam4 website. But then there's another way, and that's the way you usually take when you take like a live in-person exam, because they hand you a paper copy of the exam, where you'll have to download the Exam4 software, and then it's like a text, like you ever used like a regular text word processor that's like, it seems like really generic and stuff like that, and you have to use that, and you cannot copy and paste things into that, because that software logs everything you do on your computer, and generally you only use that software if they're like, I don't want you using the internet at all when you're taking this exam, and they'll say it's like closed or open exam. So if it's a closed exam, when you download the Exam4 web, or when you start the Exam4 software, it shuts down the internet on your computer. Like you cannot use the internet on your computer. And so you just have to sit there. Like you have to have sometimes it won't even let you run any programs. Like it won't let you open up your notes on your computer. So if that's the case, you print your notes, or your outlines, have your outlines and anything you want printed out, because you're not going to be able to open up anything else on your desktop while the Exam4 software is running. So it depends. I don't know what she said. I know for us, it was, you just went in and downloaded the exam off of the Exam4 website, and then you did it in Word, and then you just submitted your Word doc via the website. And you guys will get this talk from the professor and everything else, but always know that as soon as the exam period starts, like the exam period is like 2 weeks. It starts like around the 1st of December, ends around the 14th of December, and your exam might not be until like the 7th or 8th, but you are not allowed to talk to your professor at all during the exam period. Like once the exam period starts, you're like incommunicado. You cannot ask them any more questions about anything during the exam period. And then additionally, if there's an issue with you and like they schedule your exam on a specific date and a time, and you can't take it on that date and time, and you have to request an alternate date and time, you do that through Dean Boggs. You do not do it through the professor. The professor cannot know that you're not taking the exam at the same time as everybody else, because they can see that exams were taken at different times, and if they, again, has to be anonymous. So if they know that you're the only one that requested a different exam time, and they see that exam, they're going to know, and it's funky. It's like an honor code violation. You get a lot of trouble if you tell the professor that you can't take the exam when everybody else does. But you'll get that whole spiel too.
Thank you.
Yeah, no problem. Man, good luck, guys. Have fun. I like civil
Last thing,
procedure.
Paul, before you go,
Yeah.
all my attorney friends have been telling me to see if we can get copies of old exams. Do you guys have any old exams from civil procedure?
So we cannot give you our exam from the spring.
Wait, not yours, like old.
Yeah,
old
no. And so you have to get them from the professor. Like they will give you the old exams. We because we're not supposed to have them. I will tell you that I do have my Civ Pro exam from the spring, but I cannot give it to you because she sent it to us.
As in, you're not supposed to keep a copy of your exam? Oh, okay. I was like, the law school library has old exams. What do you mean you can't get old exams?
Like old exams, but the exam that you yourself took, you're not.
Okay.
You're supposed to like destroy it. Even your answers, you're supposed to like officially you're supposed to get rid of all that stuff and not have it anywhere in case somebody steals it and blah, blah, blah. So yeah, you can go through the library. Actually, the library does have old exams. Like right now, you can go in. You just have to get lucky. It's like, so for us, it was Karsten's first semester teaching Civ Pro, so there were no Karsten's old Civ Pro exams in the library database. So she had to give us one of her old exams from like a prior time. Sometimes they'll tell you like, oh, you can use Gifford's exam or somebody else's. Like it depends, but you have to ask her for it. We can't give you ours. Like I said, what she did was, because of the way we took the exam last year, she gave us a copy of the exam after what she'll do is she'll give you like kind of an answer key afterwards. She'll be like, here's what you should have said, to kind of give you, that's how you get your feedback. And then what happened was we all kind of raised our hand. We're like, hey, like this doesn't make sense to us. Can you send us our exams back? And so she sent it back to us. But just as like a favor. And then of course there's a lot of like, I promise not to fucking share this outside of this class. But generally, yeah, you're supposed to keep all that stuff all top secret. Unless you're talking amongst yourself. Like we always have like some happy hour or something after exams and we're like, oh my God, did you get the answer to this one or whatever? And I'm always like, oh, I missed that, or I'm always made to feel stupid.
Well, thanks anyway.
Yeah. Okay. Don't worry about it yet. Not yet. Like start looking at practice exams maybe sometime in October. After you've like studied a lot of things. If you guys got the Acing Civil Procedure book, especially the digital version, there's a bunch of cool like practice quizzes and things like that. Really helpful. Helped me a lot. So you can take those, but those are all like multiple choice. It's nothing like the exam you would take, but it's just multiple choice questions, but it helps you. Again, I can't tell you how I did in Civ Pro because we got all pass fails. So I know.
So I guess you passed.
I did. I got a P. And like, so not to be like whatever, but I told her, I talked to Professor Carson this summer about you guys specifically and how I was a peer advisor and how you guys are going to be in her class with no senior students, like no 2Es to kind of help you guys understand stuff and understand how to ask questions and things like that in class. So we had a conversation about like, I asked her, I was like, is it cool if I email you stuff and be like, how are these guys doing? Do you see, are they struggling in a certain way? And should I help them study a certain way? And she was like, oh yeah, and you're like the perfect person to do that. I was like, all right, cool. That means that at least she thinks I'm okay. Like I didn't get like a D-, and she's like, I gotta pass this asshole just so I don't have to see him ever again. but cool. All right, I'm gonna stop recording this now.
Thank you.